show that talks about everything to do with personal injuries in Victoria. My name's Tony Carbone. I'm a personal injury lawyer of over 25 years' experience. With me tonight, I've got a partner in the law firm, Nunzio Tartaglia. Good evening, Nunz.
Tony, Vivian, viewers, welcome.
Also, Vivian Ryan, ex-lawyer come marketing guru. Good evening, Viv.
Hi, Tony. Hi, viewers. Hi, Nunz.
And tonight, viewers are going to be talking about litigation funding. We've got a very interesting guest. His name's Alex Martin. He'll be on just after our break.
Tony, before we kick off though, what's in the news?
Viewers, there's been a lot of interesting stories in the news, and one of the ones I've got, I took it out of a Times in England. It's a lady, Nunzio, who got sacked, single lawyer who went into a relationship and the employer took umbrage to that. Give me the facts. Yeah,
look, it's crazy version of events, Tony. Effectively, this lawyer said wasn't on big money in London or in England. Started a relationship and her employer didn't like it, and effectively she was dismissed because of that. Look, he's very unreasonable in what he wanted of her and expected of her. Wanted her to, go to marketing events on the weekend, and wanted her to be single in those events. It's crazy. If it happened in Victoria, it'd be
an outrage.
Big actions.
Viv, she was on about $75,000 equivalent Australian dollars, 10-year lawyer, so she's not on a lot of money, is she?
No, well, no.
And the expectations were just totally unreasonable by the employer. Staying single, would that impact on your capacity to do your job properly?
Well, absolutely, there'd be psychological issues. If you're not happy at home, then arguably you're not necessarily as happy as you could be at work. So, I mean, I find this sorts of behaviour quite outrageous for employers to feel that they can, take such actions beyond the confines of your working environment. And I just question, if that did happen here in Australia, what sort of rights to her own compensation would she be entitled to?
She could go under the Fair Work Act, Nunz, go to the Federal Court of Australia, where a judge would go absolutely to town on this law firm, not to mention the effect it would have on the reputation of the law firm, Viv.
Oh, look, that's really harmful and damaging, as you well know. A brand of a business means everything.
And Nunz, whilst we're on this topic of adverse action, that's what it is, effectively. We've got the result of Sally Ann Robinson in the federal court. This is that case against Rivers.
Tony, in the last couple of weeks, I think Sally Ann Robinson and also Kate Shea from Energy Australia, I think they've occupied the first couple of pages of the Herald Sun almost every day. They've both got actions against their respective employers. Sally Ann Robinson was against the Rivers boss, Philip Goodman, effectively for sexual harassment, and similar for Kate Shea for Energy Australia for, effectively an environment of bullying, sexual harassment. I've never seen it so intense in terms of scrutiny in the papers.
Viv, am I going too far to say to the employers, beware?
No, absolutely not. I think, ultimately we are all different people, employers, employees, and I think, people need to be put on notice as to how their behaviours are received by particular individuals, whether you're in what capacity you are operating in. I'm quite a tactile human being. Some people might not like a little bit of a hand.
Touchy,
and so that's really something that employers, particularly as a result of these circumstances, really need to be put on notice as to how they behave in a work environment.
And it's been interesting, like the level of detail that's coming out in these cases. You've just got to be careful in everything you say, you do, you write down, any communication, because I said it's coming out, it's ridiculous.
And because it can be misconstrued. I mean, these people may well be very, very lovely characters, and unfortunately it's been misunderstood in the way in which in these circumstances, perhaps not. It's settled now, so we will never really truly know. I think it's just one of those things that you can be the nicest person in the world, but some certain actions can be taken quite offensively by certain people.
And guys, the other thing is this, the damages aren't covered by any insurance, so it comes out of the coffers of the company, and it's unlimited. The judges don't have a limit to what they can award. And furthermore, the damage to the brand, as Viv would say. I mean, it's irreparable, really.
Look at this case of Kate Shea, Tony. She was on almost 500 grand a year. So we're talking that's a massive salary package. And, if they're going to pay out, if it's unlimited and it's uncapped and she's successful, which we'll find out in the upcoming weeks.
Could be the biggest judgment in Victorian history.
This could be millions. And if and that's not covered by insurance, so you've got to it's damaging.
Well, viewers, stay tuned for future episodes because we'll take up that case in due course. I'm sure there'll be a result in the not so distant future, so please stay tuned. Look, this Essendon thing, I'm sick and tired of it now. I mean, I'm sure you are too, being such a parochial Essendon supporter.
Yeah, it hurts, Tony, it hurts.
What's your take? I mean, surely you can't be too unobjective about it. I mean, poor governance.
Look, I just I suppose, finalise it with the viewers. The ruling came down last Tuesday, I think it was, and effectively Essendon was fined $2 million. Draft picks were... for the next 2 years are now gone, and James Hurd's still down for 12 months. The other, key players have been suspended and, obviously banished from the final. So, look, I understand that you had to hand down a penalty, but, look, I just wish it didn't get to that point. But
Viv, your take on this?
Well, it's unprecedented, isn't it?
Yeah.
This hasn't happened before, and hopefully that other clubs now really take notice of, the ramifications of certain actions. And I think it's unfortunate. I really do actually feel sorry for James Hird for having to take a fall like this, and for the team.
The interesting part is that the doctor hasn't finalised his case, and he's actually issued Supreme Court proceedings. He wants an independent judge or panel to hear his case. And
I don't think that's not an unfair request, because, I mean, it impacts on his capacity to practice as a doctor.
Yeah, look, because I think he's got insurance issues, because if he does, make concessions, then he might not be able to practice. So
exactly.
But Tony, what happens if he's found, he doesn't get any penalties? Has Essendon called it too early?
Not necessarily, because the governance issue is big. Yeah. I mean, I don't think that, look, without getting all the Essendon supporters offside, I don't think that you could run a club where you're injecting players with whatever and you don't keep records. I mean, that is very, very poor behaviour. So, look, no, I think that what's happened is probably appropriate in all the circumstances, albeit I don't know about the penalties.
Well, I say bring on 2004.
And I say bring on the grand final.
And I say the Hawks are going to win the flag. So anyway, let's keep moving. What about this nurse, Viv? Give me the facts. This is bizarre, isn't it?
In a single shift, this particular nurse working at the Royal Melbourne Hospital had conducted 4 counts of misconduct's probably the harsh word, but however, she was definitely operating outside of the nursing scope. And one of those incidents included her trying to force feed a patient who had clearly been marked on its bedside not to be fed by the mouth. Another one involved a Q-tip where she tried to clean a patient's mouth that had been covered in acetone because she had misread the label. She's now been struck off the nurses' register, but she's due to reapply in 2 years' time. And I just wonder...
She's incompetent. You can't possibly have people like her.
Well, VK actually said, I think their quote was alarming lack of competence.
What about her giving... This lady's got a low heart rate.
Low blood pressure.
And she's given them...
Blood pressure tablets.
Yeah.
But I guess in this circumstances, we know of only 4 patients who have been victims. What compensation would they have? I mean, obviously, they haven't had long-term damage, but...
Well, look, if there was long-term damage, then they could have a case in medical negligence, and, with blatant cases like that have some very strong cases when they don't.
All I know is, thank Christ she's out of the system, and believe me, all the other ones out there that are complacent or not paying enough attention, you're next. We've got so many cases of this out there.
Look, I'd also probably say, the hospital's got to make sure they're, employing the, appropriately trained nurses and doing the appropriate checks. So.
This is a good time for them to go on Facebook and Twitter. I'd love to hear what the viewers have got to say.
Yeah.
Viv, thanks for coming on board. We've come to the end of the segment. Viewers, stay tuned. After the break, we've got Alex Martin, litigation funding. Viewers, welcome back to the show. Before the break, as I told you, we're going to have Alex Martin, the CEO of Quantum Funding, on the show. Now, the whole idea of Quantum Funding is this. These days, when you're running litigation, it becomes very, very expensive. Alex's company is there to fund your disbursements so that you get a fair crack at winning your case, because you start talking about engineers and court fees and medical reports, etc., etc. Alex, just on that note, your organisation, how long has it been around?
We've been around since 2006, Tony, funding people's disbursements across Australia.
And how do you work?
Basically, you need to go and see your lawyer about it. you approach your lawyer to get advice about your case. The lawyer says, yes, you've got a great case, your disbursements are going to be this much, and then your lawyer will approach us, and then we'll provide funding for those disbursements.
And Nunzio, why is it important that a firm like Alex's provides disbursements to people like yourself and myself so that we can pursue these claims?
Well, look, you just said it there, Tony. It enables law firms to pursue claims for plaintiffs because, look, it's an expensive process, and injured people deserve sort of access to justice, and it's hard to, if you're funding thousands of claims to get a law firm who can fund that. So it gives the ability to prosecute these claims and give yourself the best possible chance of compensation. But just to clear up for the viewers, Tony, what is disbursements? Because some people don't know what disbursements are.
Viewers, what happens is this. More often than not, when you come to a plaintiff law firm that does personal injuries, you've got to spend a lot of money to get your action into a courtroom. And the disbursements that are common are medical reports, and they're very expensive these days. There's experts in terms of orthopaedic surgeons, neurosurgeons, psychiatrists. There's court fees that are very, very exorbitant these days. You might need an engineer or two, and they're very expensive. You might need an occupational rehabilitation officer, like you did that really big cerebral palsy case. Yep. What was the disbursements in that case?
Look, they totaled up to sort of 30,000, 40,000. That's taking outside counsel's fees, or barristers' fees. And, it's basically everything outside the work that the law firm does. There's things that they just pay out. There's the invoice, we pay it out. So it's really important to have, a funder to help out with that.
And Alex, unlike conventional banking, the beauty of your organisation is you don't expect interest to be paid monthly. Can you explain that for us?
That's right, yeah. So it's different to a bank loan. It is a loan to cover your disbursements, specifically for your legal costs, but it's different to a regular loan in the sense that you don't need to pay any costs at all, don't need to pay any interest, any charges until the matter's resolved. So if your matter doesn't resolve successfully, then you don't need to pay anything. And if it does resolve successfully, then that's when you make the payment. So the payment comes out of your settlement proceeds. Different to a bank loan, you're not paying it as you go.
Alex, do you have to measure the merit of the claim, or is it simply just you base it on the law firm's advice? How do you work in that regard?
Generally speaking, we have a relationship with the law firm, and we understand how the law firm assess the cases, and so we look at the law firm's assessment and we say, okay, yes, we're happy with this case, we think it's going to be successful, and therefore we'll fund it. So it's about the law firm.
Quantum funding also does family law funding.
That's right.
And how does that differ? Because you said you actually also fund the litigation as opposed to just the disbursement, is that right?
Yes, that's right. So in the case of personal injury cases, normally law firms do it on a no-win, no-fee or a deferred fee basis, so you don't pay till the end. Yep. Whereas in family law, often you pay as you go. Yep. And so we offer a loan which allows you to pay the entire legal bill as you go, and then you pay at the end. So it's a similar type of arrangement.
Can I say this? I've had to engage lawyers to do things for me personally, and I can't believe how expensive it is. So I think plaintiffs in personal injuries are reasonably fortunate that the plaintiff lawyers are prepared to wait until the end of a case to get paid.
Absolutely.
What do you think about that?
Absolutely. It's not just that the costs are high, it's that most businesses need payment month to month. They can't afford to wait. Yeah, that's right. They can't afford to wait 2 years to be paid, whereas personal injury law firms, I think plaintiffs are lucky that they're set up in a way that they can wait the 2 years and get paid at the very end. Similarly, we're the same. Most finance companies need to get money in each month, but we wait until the end. So it's structured specially to meet the needs of people with personal injury claims.
And before you said that you pick your mark in terms of which law firms to work with, is that correct?
Yes, that's right. So we have relationships with particular law firms. So if somebody's interested in funding, they need to speak to their law firm. Then if we have a relationship with them, great. And if we don't, then the law firm needs to contact us, or the client contact us, and set a relationship up.
So you really do your due diligence on the law firm before you start giving money out, don't you?
That's right. So it's only with approved firms that we work. And so you can have some confidence that if you're getting a funding arrangement, it's with a firm that's got a good reputation and that runs a good number of cases, has a good success rate, all that sort of stuff. Because when you're picking a law firm, it's very difficult to pick the right one. And most personal injury litigants don't have much experience with lawyers. And so it's helpful to know that if you're going to one that's got a good reputation.
Thanks for your endorsement, mate. That's right. No, it's just curiously, right, and this is for the viewer's sake. Yep. When you do a case like this, assuming something goes wrong and the case doesn't succeed, you know, you haven't been able to settle it, the case is run to court and you fail, is the client out of pocket?
What that means is that if the case doesn't come to fruition and succeed, you know, like we expected at the start, because look, litigation does change throughout the course of proceeding. The plaintiff or the client is not off for any fees at all. It's effectively it's guaranteed by the law firm. So it gives the injured person some sort of, I suppose, confidence that, you know, they may not win the case, but they're not going to be also exposed to a big cost order from the, you know, from their law firm. And, you know, that's, you've got to have that sort of confidence in your law firm. So, you know what, they're taking the risk and, you know, I'm on board with them. So that's why it's important that you see lawyers, because they'll make the call early on whether you've got a valid case or not. So.
But Alex, just on the issue of disbursements, you don't fund the opposition's disbursements, do you? You're only funding
only plaintiffs.
The injured person's disbursements.
Yes, that's right. So we only fund injured people's disbursements, only plaintiffs. So we don't fund insurance companies or anything like that. It's all about injured people getting the compensation that they need.
Alex, people might, you know, listen to this and think, you know, it could be complicated. How easy is the process from? Look, I appreciate that the lawyers are the one signing the client up, but how easy is the process?
Basically, if you ask your lawyer about it, they'll give you a set of documents, which will be the loan contract, an application form. You fill in the application form and give it back to your lawyer, and your lawyer will pass it on to the funder, and that's it. So it's very straightforward. All you need to really know is that you'll borrow money up to a certain limit to pay for your disbursements, and then that'll be repaid out of your settlement proceeds. And again, as you were saying before with your fees, if you're unsuccessful, if the case doesn't resolve, then you don't have to pay anything.
On the issue of the funding arrangements you've got, who invests in your organisation?
So we've got a mixture of shareholders and borrowings. So we've borrowed some money to run the business, and we've also got shareholders who own the business.
And so effectively you don't have the same pressures as, say, a bank or a finance company, do you?
That's correct, Tony. Yeah, we don't borrow from big banks. We don't have the same requirements that the banks have. We're really specialised to deal in this market only.
That's important.
And in that case, you're not knocking on Nunzio's door saying, Nunzio, I've lent you $10,000. I want my money back. Is that correct?
That's right. Yes. There's none of that. Most of our money comes from shareholders, a small number of privately held shares.
And because you've got a legal background, you understand that litigation takes time and that you can't rush that process.
That's right. I'm from a legal background, not from a finance background, and so are all our staff. It's really about a product that meets the needs of personal injury litigants. It's not about, you know, a bank loan. It's a specialised product.
Viewers, we've got to go to a break. Stay tuned. After the break, we're going to tell you a bit about champerty and maintenance. Welcome back to the show. Before the break, we're talking about litigation funding, but I also threw up this thing about champerty and maintenance. Alex, what is champerty and maintenance?
Champerty and maintenance are very old legal concepts, hundreds of years old, to do with the improper support of litigation. So it was an old idea that supporting litigation by financing litigation is an improper thing to do and somehow leads to bad outcomes in the justice system. So
what you're saying is that the law didn't encourage litigation funding because they thought that it was encouraging vexatious litigation.
That's exactly right, Tony.
Or spurious litigation.
That's exactly right. The idea was that if two parties are on an even keel and one party's got all this finance, then that's unfair and it'll lead to bad outcomes. But the reality is quite the opposite. Often parties aren't on an even footing, and so by supporting one party, you put them on an even footing. And the High Court's recognised that. In 2006, there was a case of the Fostiff case, which recognised
Campbell's
that.
Cash and Carry, 2006.
Right. Yes.
That abolished the old principles of champerty and maintenance in the civil area, correct?
Yes, that's right. So it was already, criminal code had abolished those things, that's right. Okay. Whereas the civil jurisdiction hadn't done that until 2006, when it was confirmed, as people suspected, that it was okay to do litigation funding in Australia. In fact, the High Court recognised that it was a worthwhile, socially helpful thing.
Yeah, they said it's not contrary to public policy and that, you know, they can, one, make a profit over, two, try and promote that litigation side of it.
Well, in the year 2013, Nunz, you'd think that the people you represent would need funding because the rules would be going the other way. You're suing companies that have got unlimited funds.
Exactly right. Look, and generally, in our area, we sue big insurance. You're suing said companies, but through their insurance companies, and they're untapped with resources, so they can go on for years and years. And
they could lock you up in interlocutory processes and everything.
Like
they
could just pile you in discovery for years. So you need access to funds, and that's thankfully these litigation funders. Give those injured people or plaintiffs or clients that access to justice. So it's really important. And
Alex, can I throw this one at you? Let's say a law firm's got 2,000 current claims roughly.
Yes.
And it costs $5,000 per file in disbursements.
Yes.
It'd make it impossible to properly run every case, wouldn't it?
That's right. Law firms, particularly smaller firms, will struggle to run a whole lot of cases where they've got to keep outlaying that disbursement cost. And so by having an arrangement with us, we pay for all of those disbursements, so it helps the client get where they need to go and it helps the law firm have the cash flow to run their business effectively.
And so what it means is that everyone's getting a fair run in terms of preparation.
That's right. It's all about evening up the balance.
All right, using the rules of relativity, Nunz, the bigger law firms would have even more problems. 10,000 claims,
exactly
5,000, that is $50 million.
Yeah, it's volume and volume. That's right. Look, it's almost becoming a must. Look, you've been in the law, obviously for 25 years, as you keep stating.
Don't worry, you still got to get there, mate. So,
You've seen the shift. Like, how's it been? Especially the last 5-6 years, you must have seen a big shift in, I suppose, the prominence of litigation funders.
It's very important because over the years, I was fortunate because I kept my overheads down. I funded it out of my own personal pocket, but as the years have gone on, the cost of living's gone up and it's very expensive to run a law firm. You need a lot of staff, a lot of secretaries, court fees have gone up. So without the funder, I think we'd have a lot of issues. We couldn't properly prepare people's cases.
Also, Tony said some law firms, as you know, ask their clients to put in maybe $4 or $5 grand by way of disbursements.
Well, that happens regularly.
And having someone like Quantum on board as a litigation fund or disbursement funder, you don't need to do that. And say, well, you know what, you give it. We've got the $5 grand covered. If you win, we pay back out your legal fees. If you don't win, you don't have to pay anything back.
I don't want to mention names, but there's other funders out there that take a chunk of the settlement, isn't there?
Yes, so you can have funding arrangements where the funder takes a percentage of the outcome, so it might be 10% or 20% or 30% of the outcome.
Yeah.
Well, it can end up that way, yes.
Well, if you do your numbers, I would have thought that in 99% of cases...
Is that more for like the real high-end cases?
That's generally for large cases, particularly commercial cases, that's right, yeah.
A legal costs agreement... What does it mean, Nunz?
Well, Tony, effectively, it's the most important document that starts the process. Effectively, in accordance with the Legal Profession Act, all lawyers, once you sign up a client or to sign up a client, must sign a cost agreement. So it's not the lawyer's decision, it's not the law firm's decision. The Legal Profession Act, which effectively governs lawyers, says you have to sign a cost agreement.
Well, in 2004, Alex, the Legal Profession Practice Act was amended and it made it mandatory for lawyers to get a client to sign a cost agreement.
Yes, that's right.
And there's a lot of things in the agreement. It's a very lengthy document explaining their rights. And it does scare people off. I guess the important thing is when do you pay costs? Isn't that the most important thing?
Yes, it's all about when you pay, particularly for personal injury litigants who it might be 2 years until they receive their compensation payment. Often they're not working, so you don't have the income. So you need to know when you need to meet your obligations.
And viewers, just on that, if you ever go to a lawyer for any matter, not just personal injuries, family law, conveyancing, whatever, if you don't sign a legal costs agreement, the lawyer would be in breach of the Act. So effectively it causes all sorts of problems. So when you sort of shy away from signing an agreement, you've got to remember it's a legal obligation on the lawyer to get you to sign it. And they can't actually represent you until it's actually signed.
Yeah. And look, I think the cost agreement, spells out your rights and your as a client as well, and I think it gives you some sort of protection as well, and you understand the process. I think it's a good document for both, and it shouldn't be one to shy away from.
Exactly. Alex, just curiously, why have the big financiers shied away from litigation funding, which has made, obviously, your shareholders a bit more richer?
In until 2006, it wasn't technically permitted in Australia, so it was 2006 that it came in, if you like.
Yep.
And at that time, soon after that was the global financial crisis, and so there wasn't a lot of money being lent in any area. And so it really took people like us, people from a legal background, to realise that this is a good area to be lending in. It makes sense for clients, it makes sense for us. And so it took a bit of trailblazing, I suppose, from us and from others to enter the market. And it's really a place just for specialised lenders, really. The banks don't do it at the moment, and there's no real signs that the banks will do it anytime soon.
Okay. It takes the stress out of running the law firm because we've got these massive overheads and we're not getting paid until we get a result. And then if we had to pay the disbursements as well, it's like paying two sets of overheads, which makes it almost impossible to run a law firm. So, Alex, I commend you and your company for doing it. Viewers, thanks for watching the show. Alex, thanks for coming on board.
Thanks, Tony.
Thanks, Tony.
Pleasure to get you on board. Also, go to Facebook, go to Twitter, look at our past episodes, stay tuned for future episodes, and viewers, please always remember to stay safe.